Legal and Privacy Brief for March 2, 2026. Kenvue, Neutrogena's parent, agreed to a $4.7 million settlement under Illinois's Biometric Information Privacy Act for collecting facial geometry through its Skin 360 app without proper consent, requiring destruction of all collected biometric images. The Pentagon designated AI company Anthropic as a supply chain risk after the company set limits on autonomous lethal decision-making and domestic mass surveillance, creating immediate compliance exposure for federal contractors using Anthropic products. The University of Hawaii Cancer Center confirmed that a 2025 ransomware attack leaked data on 1.2 million individuals, including social security numbers sourced from state transportation and voter registration records. Here's the full breakdown of today's top legal and privacy stories. Next section, Enforcement Actions. Neutrogena Skin 360 BIPA Settlement Melzer, et al. V. Johnson & Johnson Consumer Inc. Case No. 3-22 CV 3149 D. NJ. Kenvue Inc., formerly Johnson & Johnson Consumer Inc., agreed to a $4.7 million settlement resolving class action claims that its Neutrogena Skin 360 app collected users' facial geometry without proper consent under the Illinois Biometric Information Privacy Act, BIPA, 740 Ilks 14/1 et sec. The settlement covers approximately 11,000 Illinois users who used the Skin 360 skin assessment tool between December 2019 and May 2023, with individual payments estimated at $427 per class member. A federal judge denied Kenvue's motion to dismiss after the company failed to establish that a statutory BIPA exemption applied. Kenvue had argued that a third party developed the underlying technology and that a disclaimer added to the Skin 360 website in 2023 was sufficient. Settlement terms require Kenvue to destroy all images collected through the Skin 360 tool during the class period, in addition to the $4.7 million cash fund. Compliance action. Any company using AI-powered facial analysis, skin assessment, or biometric features in consumer-facing apps must audit consent flows now. BIPA requires informed written consent before collection, storage, or use of biometric identifiers. A vague, later-added disclaimer does not satisfy this standard. Third-party development of the underlying technology does not shift liability away from the deploying company. Source: Top Class Actions. Eureka Casino Data Breach Settlement in Re. Eureka Casino Breach Litigation, Case No. 2-23 CV 276 CDS NJK, D. Nev, Eureka Casino agreed to a $1 million class action settlement for a data breach between November 9 and 13, 2022, that compromised names, social security numbers, financial account numbers, passport numbers, and driver's license numbers. Plaintiffs alleged the casino failed to implement reasonable cybersecurity measures and violated Nevada's data breach notification statutes. Class members can receive up to $5,000 for documented losses, with California residents eligible for an additional $100 statutory cash payment. Claim deadline is May 11, 2026. The final approval hearing is scheduled for June 10, 2026. Compliance action. Nevada requires breach notification without unreasonable delay. This settlement reinforces that inadequate security controls can constitute both a statutory violation and a breach of contract with customers. Hospitality and gaming organizations should document incident response and notification procedures now, not after a breach occurs. Source: Top Class Actions. German conviction Milton Group Investment Fraud Network. The Bamberg Regional Court in Bavaria sentenced Mikhail Bainiashvili to 7.5 years in prison for operating the Milton Group, a call center fraud network that caused €8 million, $9.4 million, in losses to victims primarily in German-speaking countries between 2017 and 2019. After leaving daily operations, Bainiashvili continued selling his Puma TS customer management and trading platform to other criminal groups, which prosecutors attributed to an additional €42 million, $49 million, in damages from copycat fraud operations. The court ordered confiscation of €2.4 million, $2.8 million, in proceeds. Bainiashvili was extradited from Armenia in 2024. The verdict is not yet final. Compliance action. The Puma TS case establishes that selling software that enables fraud operations can generate ongoing criminal liability even after an operator exits day-to-day involvement. Fintech and investment platforms should audit vendor agreements covering customer-facing communication tools and maintain controls that prevent their systems from being repurposed for fraudulent solicitations. Source: The Record. Next section, Litigation Updates. Betterment Dual Data Breach Class Actions Tsu v. Betterment LLC et al., Case No. 1-26 CV 444 and Huff et al. v. Betterment Case No. 1-26 CV 364, SDN. Y. Two separate class action lawsuits were filed in January 2026 in the Southern District of New York against Betterment, a fintech company, following a January 9, 2026 breach. Attackers obtained access credentials through social engineering, used those credentials to access customer PII, names, email addresses, physical addresses, phone numbers, and dates of birth, and then exploited Betterment's own approved marketing and communication channels to send fraudulent sales solicitations to customers. A subsequent DDoS attack disrupted Betterment's website and app on January 13, 2026. Plaintiffs allege negligence, invasion of privacy, and breach of fiduciary duty. Compliance action. This breach illustrates the risk of credential attacks that then weaponize internal marketing platforms. Phishing-resistant MFA, multi-factor authentication, should be deployed on all systems with access to customer PII. Third-party marketing platform integrations should be included in access control and anomaly detection reviews. Outbound communication monitoring can detect breach-enabled abuse before customers are harmed. Sources: Top class actions. Bumble Data Breach Class Action O'Meara v. Bumble Inc., Case No. 1-26 CV 398 WD. Tex. A class action filed in the Western District of Texas alleges Bumble failed to implement adequate security measures to protect customer PII during a January 2026 breach. Plaintiff claims Bumble failed to follow required protocols for data encryption and did not properly secure servers. Claims include negligence, breach of implied contract, breach of the implied covenant of good faith and fair dealing, unjust enrichment, and violations of the Texas Deceptive Trade Practices Act. The plaintiff seeks declaratory and injunctive relief plus damages for a nationwide class and Texas subclass. Source: Top class actions. University of Hawaii Cancer Center ransomware breach 1.2 million individuals, affected the University of Hawaii Cancer Center, disclosed that a ransomware attack discovered August 31, 2025, resulted in data exposure for approximately 1.2 million individuals. The breach affected epidemiology research servers containing social security numbers and driver's license numbers sourced from the Hawaii State Department of Transportation and City and County of Honolulu voter registration records dating back to 1998. Approximately 87,493 research study participants had data directly exfiltrated. The broader 1.15 million figure stems from historical government records retained on research infrastructure. The university paid a ransom and obtained an affirmation from the attackers that data was destroyed, though no independent verification of destruction was reported. The threat actor has not been publicly identified. Compliance action. This breach illustrates the risk of retaining historical government-sourced data sets, voter rolls, DMV records, on research servers without adequate isolation. Organizations holding legacy government data should conduct retention policy audits and ensure these data sets are stored in segmented, hardened environments. The gap between the August 2025 discovery and the January 2026 legislative report should also prompt a review of applicable state breach notification deadlines. Source: The Record. Joybird False Advertising Class Action German, et al. v. Stitch Industries Inc., Case No. 2-26 CV 1820 CD. Cal. 3 consumers filed a class action in the Central District of California, alleging Joybird perpetually advertises 30-50% discounts taken from inflated reference prices that do not reflect any genuine regular price. Plaintiffs allege violations of California's Consumers Legal Remedies Act, false advertising law, and unfair competition law. Joybird previously settled a related case for $7.15 million covering California, Oregon, and Washington consumers. This new action targets purchasers in other states. Source: Top Class Actions. Hunter v. United States SCOTUS on Appellate Waiver Scope. Argument. March 3, 2026. The Supreme Court is scheduled to hear oral argument March 3 in Hunter v. United States, addressing how broadly federal defendants can waive their right to appeal as part of a plea agreement, and whether a district court's post-sentencing statement that a defendant has a right to appeal can override a previously executed appellate waiver. The Fifth Circuit enforced the waiver and ruled the court's statement did not nullify it. The outcome will affect how prosecutors structure plea agreements and the enforceability of broad waiver language going forward. Source: Scadu S. blog. Next section, Policy Changes. Pentagon designates Anthropic as Supply Chain Risk. Defense Secretary Pete Hegseth designated Anthropic a supply chain risk, effectively prohibiting entities with U.S. military contracts from maintaining commercial relationships with the company. The designation followed Anthropic's position that its AI should not make autonomous lethal decisions without human oversight and should not be used for domestic mass surveillance of U.S. citizens. This is the first known supply chain risk designation against a domestic AI company based on ethical use restrictions rather than foreign government ties or documented security vulnerabilities. Lawfare Research Director Alan Rosenstein published legal analysis of the Defense Production Act questions raised by the designation. His analysis was cited in over 40 major outlets including CNN, Bloomberg, and the Financial Times. Compliance action. Federal contractors and subcontractors using Anthropic's API or Claude models in any product or internal tool should immediately assess contract compliance requirements. If your contracts include supply chain risk clauses, consult legal counsel on whether continued Anthropic use creates exposure. Document your AI vendor risk assessments and maintain substitution contingency plans. Sources: Tech Dirt Lawfare. UK NCSC heightened cyber alert following Middle East strikes. The UK National Cyber Security Centre issued an advisory following US and Israeli strikes on Iran that killed Supreme Leader Ayatollah Ali Khamenei. The NCSC assessed likely no current significant change in the direct cyber threat from Iran to the UK, but warned of a heightened risk of indirect cyber threat for organizations with assets or supply chains in the Middle East. A suspected Iranian drone struck the RAF base in Cyprus. Others were intercepted. The alert advised all organizations to review security guidance and directed critical national infrastructure operators to prepare for severe cyber threats. Compliance action. U.S. and UK organizations with Middle East supply chain exposure should review incident response plans immediately. This advisory mirrors prior U.S. government warnings about Iran-linked threats to energy, telecommunications, and financial sector infrastructure. Organizations should verify that threat intelligence feeds and detection rules are updated to reflect Iranian threat actor TTPs, tactics, techniques, and procedures. Source: The Record. Next section, Privacy Developments. LLM-assisted de-anonymization at scale published research. demonstrates that LLM agents can identify individuals from anonymous online posts across Hacker News, Reddit, LinkedIn, and anonymized interview transcripts with high precision, and at scale across tens of thousands of candidates. The research confirms that combining multiple contextual data points from posts enables identification even when no single attribute is uniquely identifying, undermining the practical assumptions underlying most current anonymization methods. Compliance action. Organizations that publish, share, or sell anonymized user data should reassess whether their methods remain sufficient. Standard k-anonymity or suppression of direct identifiers is no longer a reliable defense against re-identification. Legal teams should revisit privacy policy language characterizing data as de-identified or anonymous, particularly under GDPR Article 4.1, CCPA de-identification standard, and HIPAA safe harbor or expert determination methods. Source: Schneier on security. Prosper data breach, 17 million affected. Mass arbitration underway. Prosper, a peer-to-peer lending platform, confirmed a September 2025 cyber attack, potentially affecting more than 17 million clients and applicants. The exposed database included social security numbers, government identification numbers, bank account numbers, tax information, passport numbers, and dates of birth. Prosper states customer accounts themselves were not accessed, but the underlying PII exposure is broad. A mass arbitration investigation is underway. Source: Top Class Actions. ECPA 40th Anniversary Event March 6, 2026. Free, Georgetown Law. Georgetown Law's Institute for Technology, Law and Policy, and Center on Privacy and Technology are co-hosting a free half-day event March 6, marking the 40th anniversary of the Electronic Communications Privacy Act. Speakers include Susan Landau, Michael Dreeben, David Criss, Jennifer Daskal, and other privacy academics and former DOJ officials. The event is timely given ongoing executive branch and legislative pressure on electronic surveillance frameworks. Source: Lawfare. In next section, compliance takeaways. Biometric consent must be obtained before collection. The new Trojan BIPA settlement case No. 3-22 CV 3149 confirms that a later added disclaimer does not satisfy Illinois BIPA informed written consent requirement. If your product touches facial geometry, fingerprints, voice prints, or retina scans, verify consent timing and scope, and audit whether third-party developers of underlying technology shift or share liability. Federal contractors must audit AI vendor relationships now. The Anthropic Supply Chain Risk Designation creates compliance exposure for any contractor with U.S., military, or federal agency contracts. Review prime contract supply chain clauses, document your AI vendor inventory, and prepare substitution plans. This situation may expand to other AI vendors. Reassess anonymization practices given current LLM capabilities. New research confirms that LLM tools can de-anonymize individuals from published data at scale using combinations of contextual attributes. Privacy policies, data sharing agreements, and safe harbor assertions that rely on anonymization should be reviewed by legal counsel. Standard k-anonymity and direct identifier suppression are not sufficient against this threat. Breach notification timelines deserve legal review. The University of Hawaii Cancer Center breach was discovered August 31, 2025, with a legislative report filed in January 2026. Many state laws require notification within 90 days. Review your jurisdiction-specific obligations, including Hawaii's Breach Notification Statute, HA, Rev. Stat. Sec. 487N, and document investigation timelines to demonstrate good faith compliance. Social engineering credential attacks require multi-layer controls. The Betterment breach, case NOS. 1-26 CV 444 and 1-26 CV 364 involved credentials obtained through social engineering that were then used to abuse internal marketing systems. Deploy phishing-resistant MFA on all systems with access to customer PII, include marketing platform integrations in access control reviews, and add outbound communication anomaly detection to your security monitoring. That concludes today's legal and privacy brief. From Carolina, Clear Tech. For informational purposes only, not legal advice.